Welcome to In Focus with Silvana Pavlovska. Today is the 30th of May, 2024. We are continuing our program related to the Macedonian question, and in particular, it is the one that is by Professor Dr. IGOR JANEV, titled The PRESPA Agreement as Cultural Genocide of the Macedonian National Identity towards the termination of an illegal treaty. A publication, scholarly publication, which came out only a few months ago, so late 2023. We've been concentrating on the appendixes of this publication, as we've already covered the 6 chapters contained in that publication. And today we'll be looking at, starting with actually Appendix 9. So I will draw your attention to Appendix 9. It is another letter, and I'll tell you more about that in one moment. Yes. Appendix 9, letter from the Minister for Foreign Affairs of Greece, addressed to the President of the President, to the President of the President of the Security Council. That's how it's written. In brackets, UN Doc S/25543. Annex, letter dated 6th of April, 1993, from the Minister for Foreign Affairs of Greece, addressed to the President of the Security Council. And it says, I write to inform you that the government of Greece considers the draft resolution currently before the Security Council an acceptable basis for addressing the issue of the application of the former Yugoslav Republic of Macedonia for admission to the United Nations. My government considers the 3 main elements of this resolution, namely the settlement of the difference over the name of the applicant state, the adoption of appropriate confidence-building measures, and the procedure for admitting the new state to the United Nations under a provisional name. An integral and indivisible package which alone can resolve the outstanding differences between Greece and the new republic, they say in their letter. Indeed, the ultimate objective of the matter is the normalization of the relations between Greece and the FYROM, they say. Only if this objective is reached can peace and stability in our region be assured. Is that a fact? Our position regarding the causes of these differences and the means to address and permanently eradicate them are included in the memorandum which we submitted to the General Secretary or Secretary General on the 25th of January, 1993. One thing must be clear at the very outset. Together with the resolution of the issue of the name, Greece attaches the highest importance to the adoption and implementation of a set of appropriate confidence-building measures by the new state vis-a-vis Greece. Such measures were already included in the so-called Pinheiro package, which was put together by the Portuguese presidency of the European Community in the spring of 1992. The CBMs must aim at securing inter alia legal and political guarantees that the new state harbors no territorial claims against Greece, which should include amendments of certain provisions of the 1991 Constitution of the FYROM, as references to the protection word is in quotation, of non-existing minorities in the neighboring countries of this new republic, and guarantees of the existence borders by both sides. The cessation of all hostile propaganda, particularly acts which could provoke public opinion and impede efforts towards establishing good neighborly relations. The termination of the use of Greek symbols, such as Son of Vergina, as symbol of the new republic. This is of a paramount importance to the Greek people. I don't know that the Greek people know about this Son of Vergina, which is the Macedonian symbol. Finally, since one of the issues for the confidence-building measures is the question of the flag, they say, I should like to underline, as I have done in verbal communications to your distinguished predecessors, that the hoisting and flying at the United Nations of the flag bearing the Son of Virginia would result in great damage to the efforts undertaken by the co-chairman of the steering committee of the International Conference on the former Yugoslavia and render more difficult, if not defeat, a solution. So they've got a problem with the flag, which has our sun, the Macedonian sun, with the 16 rays. They've got a problem with that one being hoisted and flying at the United Nations. Lots of problems. Chip on the shoulder. There's Silvana's commentary. I should be grateful to you, Mr. President, if you would bring the serious concerns of my government to the attention of the Secretary General so that the problems that might be created by the hoisting of the flag be avoided. Signed, Michael Papakonstantinou, Minister for Foreign Affairs of Greece. So that was Appendix 9, a letter from the Minister for Foreign Affairs of Greece addressing the President of the Security Council with their concerns. Appendix 10. We're just about going to sort that one out. So Appendix 10, International Court of Justice. Conditions of admission of a state to membership in the United Nations, Article 4 of the Charter. The court, composed as above, it says, gives the following advisory opinion. And on November the 17th, 1947, the General Assembly of the United Nations adopted the following resolution, quotation, the General Assembly, considering Article 4 of the Charter of the United Nations, considering the exchange of views which has taken place in the Security Council at its 204th, 205th, and 206th meetings relating to the admission of certain states to membership in the United Nations, considering Article 96 of the Charter, requests the International Court of Justice to give an advisory opinion on the following question. This is very important to pay attention. Is a member of the United Nations, which is called upon in virtue of Article 4 of the Charter to pronounce itself by its vote, either in the Security Council or in the General Assembly, on the admission of a state to membership in the United Nations, judicially entitled to make its consent to the admission dependent on conditions not expressly provided by paragraph 1 of the said article. In particular, can such a member, while it recognizes the conditions set forth in that provision to be fulfilled by the state concerned, subject its affirmative vote to the additional condition that other states be admitted to membership in the United Nations together with that state? Instructs the Secretary General to place at the disposal of the court the records of the above-mentioned meetings of the Security Council. By a note dated November the 24th and filed in the registry on November the 29th, the Secretary General of the United Nations transmitted to the registrar a copy of the resolution of the General Assembly. In a telegram sent on December the 10th, the Secretary General informed the registrar that the note of November 24th was to be regarded as the official notification and that certified true copies of the resolution can be dispatched. These copies reached the registry on December the 12th, and the question was then entered in the general list under number 3. The same day, the registrar gave notice of the request for an opinion to all states entitled to appear before the court in accordance with paragraph 1 of Article 66 of the statute. Furthermore, page 59, as the question put mentioned Article 4 of the Charter, the registrar informed the governments of members of the United Nations by means of a special and direct communication as provided in paragraph 2 of Article 66, that the court was prepared to receive from them written statements on the question before February the 9th, 1948. The date fixed by an order made on December the 12th, 1947 by the President, as the court was not sitting. By the date thus fixed, written statements were received from the following states: China, El Salvador, Guatemala, Honduras, India, Canada, United States of America, Greece, Yugoslavia, Belgium, Iraq, Ukraine, Union of Soviet Socialist Republics, and Australia. Australia too. These statements were communicated to all members of the United Nations, who were informed that the President had fixed April the 15th, 1948 as the opening date of the oral proceedings. A statement from the government of Siam dated January the 30th, 1948, which was received in the registry on February the 14th, that is, after the expiration of the time limit, was accepted by decision of the President and was also transmitted to the other members of the United Nations. By its resolution, the General Assembly instructed the Secretary General to place at their disposal of the court the records of certain meetings of the Security Council. In accordance with these instructions and with paragraph 2 of Article 65 of the statute, where it is laid down that every question submitted for an opinion shall be accompanied by all documents likely to throw light upon it. The Secretary General sent to the registry the documents which are enumerated in section 1 of the list annexed to this present opinion FN1. A part of these documents reached the registry on February the 10th, 1948, and the remainder on March the 20th. The Secretary General also announced by a letter of February the 12th, 1948, that he had designated a representative authorized to present any written and oral statements which might facilitate the court's task. Furthermore, the governments of the French Republic, of the Federal People's Republic of Yugoslavia, of the Kingdom of Belgium, of the Czechoslovak Republic, and of the Republic of Poland announced that they had designated representatives to present oral statements before the court. By decision of the court, the opening of the oral proceedings was postponed from April the 15th to April 22nd, 1948. In the course of public sittings held on April 22nd, 23rd, and 24th, the court heard the oral statements presented. On behalf of the Secretary General of the United Nations, by its representative, Mr. Ivan Kerno, Assistant Secretary in charge of the Legal Department, page 60. On behalf of the government of the French Republic, by its representative, M. Georges Scale, Professor at the Faculty of Law of Paris. On behalf of the government of the Federal People's Republic of Yugoslavia, by its representative, Mr. Milan Bartoš, Minister Plenipotentiary. On behalf of the government of the Kingdom of Belgium, by its representative, Mr. Georges Kajakenbik, DCL, Minister Plenipotentiary, excuse me, head of the Division for Peace Conferences and International Organization at the Ministry for Foreign Affairs, member of the Permanent Court of Arbitration. On behalf of the government of the Republic of Czechoslovakia, by its representative, Mr. Vladimir Votchkot, Professor of International Law in Charles University at Prague, I beg your pardon. On behalf of the government of the Republic of Poland, by its representative, Mr. Manfred Laks, Professor Agrere of International Law at the University of Warsaw. In the course of the hearings, new documents were filed by the representatives accredited to the court. These documents are enumerated in section 2 of the list annexed to the present opinion FN1. Before examining the request for an opinion, the court considered it necessary to make the following preliminary remarks. The question put to the council is divided into two parts, of which the second begins with the words "in particular," and is presented as an application of a more general idea implicit in the first. The request for an opinion does not refer to the actual vote. Although the members are bound to conform to the requirements of Article 4 in giving their votes, the General Assembly can hardly be supposed to have intended to ask the court's opinion as to the reasons which, in the mind of a member, may prompt its vote. Such reasons which enter into a mental process are obviously subject to no control, nor does the request concern a member's freedom of expressing its opinion. Since it concerns a condition or conditions on which a member, in quote, makes its consent dependent, end of quote, the question can only relate to the statements made by a member concerning the vote it proposes to give. It is clear that the General Assembly's resolution of November the 17th, 1947, that the court is not called upon either to define the meaning and scope of the conditions on which admission is made dependent, or to specify the elements which may serve in a concrete case to verify the existence of the requisite conditions, page 61. The clause of the General Assembly resolution referred to, quotation, the exchange of views which has taken place, end of quote, is not understood as an invitation to the court to say whether the views thus referred to are well-founded or otherwise. The abstract form in which the question is stated precludes such an interpretation. The question put in effect confined to the following point only. Are the conditions stated in paragraph 1 of Article 4 exhaustive in character, in the sense that an affirmative reply which would lead to the conclusion that a member is not legally entitled to make admission dependent on conditions not expressly provided for in that article, while a negative reply would, on the contrary, authorize a member to make admission dependent also on other conditions. Understood in this light, the question in its two parts is and can only be a purely legal one. To determine the meaning of a treaty provision, to determine, as in this case, the character, in brackets, exhaustive or otherwise, of the conditions for admission stated therein, is a problem of an interpretation and consequently a legal question. It has nevertheless been contended that the question put must be regarded as a political one, and that for this reason it falls outside the jurisdiction of the court. The court cannot attribute a political character to a request which, framed in abstract terms, invites it to undertake an essentially judicial task, the interpretation of a treaty provision. It is not concerned with the motives which may have inspired this request, nor with the considerations which, in the concrete cases submitted for examination to the Security Council, form the subject of the exchange of views which took place in that body. It is the duty of the court to envisage the question submitted to it only in the abstract form which has been given to it, noting or nothing which is said in the present opinion refers either directly or indirectly to concrete cases or to particular circumstances. It has also been contended that the court should not deal with a question couched in abstract terms, that is, a mere affirmation devoid of any jurisdiction. According to Article 96 of the Charter and Article 65 of the Statute, the court may give an advisory opinion on any legal question, abstract or otherwise. Lastly, it has also been maintained that the court cannot reply to the question put because it involves an interpretation of the Charter. Nowhere is any provision to be found forbidding the court, quotation, the principal judicial organ of the United Nations, end of quote, to exercise in regard to Article 4 of the Charter a multilateral treaty, an interpretative function which falls within the normal exercise of its judicial powers. Accordingly, the court holds that it is competent on the basis of Article 96 of the Charter and Article 65 of the statute and page 62 considers that there are no reasons why it should decline to answer the question put to it. In framing this answer, it is necessary first to recall the, in quotation, conditions required, conditions is in quotation, required under paragraph 1 of Article 4 of an applicant for admission. This provision reads as follows, quotation, membership in the United Nations is open to all other peace-loving states which accept the obligations contained in the present charter and in the judgment of the organization are able and willing to carry out these obligations. End of quote. The requisite conditions are 5 in number to be admitted to membership in the United Nations. An applicant must, 1, be a state, 2, be peace-loving, 3, accept the obligation of the Charter, 4, be able to carry out these obligations, and 5, be willing to do so. All these conditions are subject to the judgment. One moment, please. Yeah. All these conditions are subject to the judgment of the organization. The judgment of the organization means the judgment of the 2 organs mentioned in paragraph 2 of Article 4, and in the last analysis, that of its members. The question put is concerned with the individual attitude of each member called upon to pronounce itself on the question of admission. Having been asked to determine the character, exhaustive or otherwise, of the conditions stated in Article 4, the court must in the first place consider the text of the article. The English and French texts of paragraph 1 of Article 4 have the same meaning, and it is impossible to find any conflict between them. The text of this paragraph, by the enumeration which it contains and the choice of its terms, clearly demonstrates the intention of its authors to establish a legal rule which, while it fixes the conditions of admission, determines also the reasons for which admission may be refused. For the text does not differentiate between these 2 cases, and any attempt to restrict it to one of them would be purely arbitrary. The terms, quotation, membership in the United Nations is open to all other peace-loving states which, end of quote, and, quote, pouvant devenir membres des nations unies tous autres états pacifiques. That's the French version, end of quote, indicate that the states which fulfill the conditions stated have the qualifications requisite for admission. The natural meaning of the words used leads to the conclusion that these conditions constitute an exhaustive enumeration and are not merely stated by way of guidance or example. The provision would lose its significance and weight if other conditions unconnected with those laid down could be demanded. The conditions stated in paragraph 1 of Article 4 must therefore be regarded not merely as the necessary conditions, but also as the conditions which suffice. Nor can it be argued that the conditions enumerated represent only an indispensable minimum, in the sense that political considerations represent only an indispensable minimum, in the sense that political considerations could be superimposed upon them and prevent the admission of an applicant which fulfills them. Such an interpretation, page 63, would be inconsistent with the terms of paragraph 2 of Article 4, which provide for the admission of, again, we've got a French word, toutes remplissant ces conditions, end of quote, quote again, any such state, meaning any such state, end of quote. It would lead to conferring upon members an indefinite and practically unlimited power of discretion in the imposition of new conditions. Such a power would be inconsistent with the very character of paragraph 1 of Article 4, which by reason of the close connection which it establishes between membership and the observance of the principles and obligations of the Charter, clearly constitutes a legal regulation of the question of the admission of the new states. To warrant an interpretation other than that which ensues from the natural meaning of the words, a decisive reason would be required which has not been established. Moreover, the spirit as well as the terms of the paragraph preclude the idea that considerations extraneous to those principles and obligations can prevent the admission of a state which complies with them. If the authors of the Charter had meant to leave members free to import into the application of this provision considerations extraneous to the conditions laid down therein, they would undoubtedly have adopted a different wording. The court considers that the text is sufficiently clear. Consequently, it does not feel that it should deviate from the consistent practice of the Permanent Court of International Justice, according to which there is no occasion to resort to preparatory work if the text of a convention is sufficiently clear in itself. The court furthermore observes that Rule 60 of the Provisional Rules of Procedure of the Security Council is based on this interpretation. The first paragraph of this rule reads as follows, quotation, "The Secretary Council shall decide whether in its judgment the applicant is a peace-loving state and is able and willing to carry out the obligations contained in the Charter, and accordingly whether to recommend the applicant state for membership. It does not, however, follow from the exhaustive character of paragraph 1 of Article 4 that an appreciation is precluded of such circumstances of fact as would enable the existence of the requisite conditions to be verified. Article 4 does not forbid the taking into account of any factor which it is possible reasonably and in good faith to connect with the conditions laid down in that article. The taking into account of such factors is implied in the very wide and very elastic nature of the prescribed conditions. No relevant political factor, that is to say, none connected with the conditions of admission, is excluded, page 64. It has been sought to deduce either from the second paragraph of Article 4 or from the political character of the organ recommending or deciding upon admission, arguments in favor of an interpretation of paragraph 1 of Article 4 to the effect that the fulfillment of the conditions provided for in that article is necessary before the admission of a state can be recommended or decided upon. But that does not preclude the members of the organization from advancing considerations of political expediency extraneous to the conditions of Article 4. But paragraph 2 is concerned only with the procedure for admission, while the preceding paragraph lays down the substantive law. This procedural character is clearly indicated by the words, in quote, "will be effected," end of quote, which, by linking admission to the decision, point clearly to the fact that the paragraph is solely concerned with the manner in which admission is effected, and not with the subject of the judgment of the organization, nor with the nature of the appreciation involved in that judgment. These two questions being dealt with in the preceding paragraph. Moreover, this paragraph, in referring to, quote, "recommendation," end of quote, of the Security Council and the, quote, "decision," end of quote, of the General Assembly, is designed only to determine the respective function of these two organs, which consist in pronouncing upon the question whether or not the applicant state shall be admitted to membership after having established whether or not the prescribed conditions are fulfilled. The political character of an organ cannot release it from the observance of the treaty provisions established by the Charter, I beg your pardon, when they constitute limitations on its powers or criteria for its judgment. To ascertain whether an organ has freedom of choice for its decisions, reference must be made to the terms of its constitution. In this case, the limits of this freedom are fixed by Article 4 and allow for a wide liberty of appreciation. There is therefore no conflict between the functions of the political organs on the one hand and the exhaustive character of the prescribed conditions on the other. It has been sought to base on the political responsibilities assumed by the Security Council in virtue of Article 24 of the Charter, an argument justifying the necessity for, according to the Security Council, as well as to the General Assembly, complete freedom of appreciation in connection with the admission of new members. But Article 4, owing to the very general nature of its terms, cannot, in the absence of any provision, affect the special rules for admission which emerge from Article 4. The foregoing considerations establish the exhaustive character of the conditions prescribed in Article 4. The second part of the question concerns a demand on the part of the member making its consent to the admission of an applicant dependent on the admission of other applicants, page 65. Judged on the basis of the rule which the court adopts in its interpretation of Article 4, such a demand clearly, quotation, constitutes a new condition, since it is entirely unconnected with those prescribed in Article 4. It is also in an entirely different category from those conditions, since it makes admission dependent not on the conditions required of applicants, qualifications which are supposed to be fulfilled, but on an extraneous consideration concerning states other than the applicant state. The provisions of Article 4 necessarily imply that every application for admission should be examined and voted. I'll just go back. The provisions of Article 4 necessarily imply that every application for admission should be examined and voted on separately and on its own merits. Otherwise, it would be impossible to determine whether a particular applicant fulfills the necessary conditions. To subject an affirmative vote for the admission of an applicant state to the condition that other states be admitted with that state would prevent members from exercising their judgment in each case with complete liberty within the scope of the prescribed conditions. Such a demand is incompatible with the letter and spirit of Article 4 of the Charter. Let me read that to you again. It says, to subject an affirmative vote for the admission of an applicant state to the condition that other states be admitted with that state would prevent members from exercising their judgment in each case with complete liberty within the scope of the prescribed conditions. Such a demand is incompatible with the letter and spirit of Article 4 of the Charter. For these reasons, the court, by 9 votes to 6, is of an opinion that a member of the United Nations, which is called upon in virtue of Article 4 of the Charter to pronounce itself by its vote, either in the Security Council or in the General Assembly, on the admission of a state to membership in the United Nations, is not judicially entitled to make its consent to the admission dependent on conditions not expressly provided by paragraph 1 of the said article, and that in particular a member of the organization cannot, while it recognizes the conditions set forth in that provision to be fulfilled by the state concerned, subject its affirmative vote to the additional condition that other states be admitted to membership in the United Nations together with that state. The present opinion has been drawn upon in French and in English, the French text being authoritative, page 66, done at the Peace Palace in The Hague, this 28th day of May, 1948, in 2 copies, one of which should be placed in the archives of the court and the other transmitted to the Secretary General of the United Nations. And it is signed by J.G. Guerrero, President, also signed by E. Hambro, Registrar. And here in front of me, as I read this publication from Professor Dr. Igor JANEV, we also have a web link to this document that I have been sharing with you with permission from our Professor Dr. Igor JANEV. And let me remind you, we have been talking about the Macedonian question, and in particular, the PRESPA agreement as cultural genocide of the national Macedonian national identity towards the termination of an illegal treaty. A scholarly publication by an expert in the area of international law, somebody who has authored many, many books in this particular field, a publication which came out in the public domain, or in the domain of those who are concerned with this particular area, end of 2023. It has been a long session this time. I'm grateful to you for your patience, but there was no way I could actually bring this last appendix from the court and their decision in one go, in segments. It had to be done in one go, and I think the purpose has been achieved. So you've been listening and watching In Focus with Silvana Pavlovska, 30th of May, 2024. 30th of May, 24. How many years has it gone since the decision by the International Court of Law? 28th of May, 1948. And now it's 30th of May, 2024. I am looking forward to seeing you soon, where we will continue with the remainder of the content of this publication. Thank you for your attention once again. See you soon.